courts.
Attorney General Kihara Kariuki has moved to the Supreme Court to challenge the verdict of the Court of Appeal on the Building Bridges initiative. Through a notice of appeal submitted on Friday, the AG seeks to have the Apex Court address 8 issues that made the Court of Appeal to overturn President Uhuru Kenyatta's bid to amend the Constitution. On top of the list of the contentious issues, Kariuki is aggrieved with the court's declaration that the basic structure doctrine is applicable in Kenya and that the doctrine limits the power of the constitutional amendments set out in Articles 255 to 257.
The power to amend the Constitution through the popular initiative route under Article 257 of the Constitution is reserved for the private citizen, for Wanjiko only. Neither the President nor any state organ is permitted under our Constitution to initiate constitutional amendments using the popular initiative route.
He is also fighting court's finding which declared that basic structure of the Constitution of Kenya can only be altered through primary constituent power, which must include 4 sequential processes.
Sovereign primary constituent power is only exercisable by the people after 4 sequential processes, namely civic education, public participation and collation of views, constituent assembly debate, and ultimately a referendum.
The Attorney General is also dissatisfied with the Court of Appeal decision that the President can be sued during his tenure of office in respect of anything done or not done contrary to the Constitution. Moreover, the AG is against the decision by the Appellate Court, which declared that the President does not have authority to initiate changes to the Constitution and that the constitutional amendment can only be initiated through a parliamentary means under Article 256 or through popular initiative under Article 257 of the Constitution.
In taking initiatives to amend the Constitution other than through the prescribed means in the Constitution, the President failed to respect, uphold, and safeguard the Constitution, and to that extent, he has fallen short of the leadership and integrity threshold set in Article 73 of the Constitution, and in particular, Article 73, 1A thereof.
The AG further said is challenging the declaration that the BBI process contravened the Constitution, in particular Article 10. Additionally, Kariuki is fighting a finding that the second schedule of the Constitution of Kenya Amendment Bill 2020 was unconstitutional, is so far it purported to predetermine the allocation of the proposed 70 new constituencies. He also falls and is attempting to overturn the court's decision to direct the Independent Electoral and Boundaries Commission on its functions of constituency delimitation.
I don't know how the BBI report or how the BBI team came up with the 70 constituencies. The allocation of the 70 constituencies to the respective counties. So I don't know what factors they took in consideration and what factors they did not take in consideration. The Commission was not consulted on that, and I don't know the source of that allocation of the 70.
The final contentious issues presented by the AGs is dissatisfaction with the Appellate Court's ruling that the constitutional amendment process was unconstitutional, usurpation of the people's exercise of sovereign power. The 8 formed the basis of the next legal duel in efforts to save BBI despite 2 defeats both in the High Court and the Court of Appeal. For Maisha Prime, Maisha Television, I'm Bushabi Jr.